What happens when a computer makes a mistake while forming a contract? Not a human typo, but an error generated by the algorithm itself. Can that count as a legal mistake under contract law? In this video, we look at Cristina Frattone's 2024 article and its core argument about whether mistake doctrine can handle machine-made contracts. Contracting is becoming increasingly automated. Systems can negotiate, form, and execute transactions with little direct human involvement. That creates a doctrinal problem because software can malfunction, rely on stale inputs, or produce outcomes the deployer never would have accepted. Frattone distinguishes between automation mistakes and autonomy mistakes. Automation mistakes are technical failures such as coding bugs or missing market data. Autonomy mistakes arise when an AI system's decision process itself produces an unwanted result despite technical operation. Across multiple legal systems, mistake usually has to concern existing facts, be fundamental, and often be recognizable to the other party. Frattone argues that some automation mistakes can still fit this structure because bad data or technical failure can function like an erroneous assumption. The real difficulty is attribution. Whose mistake matters in law? The programmers, the deployers, or the systems? And whose knowledge matters when assessing what the counterparty knew or should have known? In Quoine VB2C2, a pricing data failure triggered a deep price fallback in an automated trading system, leading to trades at about 250 times the market rate. The case turned the abstract attribution problem into a concrete dispute about automated execution and irreversible trades. The majority focused on the programmer's state of mind at the time of coding. Lord Mance's dissent focused instead on whether the error should have been obvious at the time of execution. Frattone suggests the execution time lens may work better for more autonomous AI systems. Frattone identifies three weaknesses. Some autonomy mistakes do not fit the doctrine at all. National rules are too fragmented for cross-border commerce, and post-trade avoidance can destabilize later transactions in fast-moving markets. Her proposal allocates baseline risk to parties that choose automation. But if the mistake is externally visible in the expressed consent and a reasonable observer would doubt the seriousness of the agreement, remedies such as withdrawal, modification, or rectification should remain available. Frattone also stresses that platform terms and framework agreements can shape outcomes just as much as substantive mistake doctrine. Quoine is therefore about both private law doctrine and private ordering. The core tension is whether private law can keep using human-centered categories once contracting decisions are delegated to systems that operate at machine speed. Frattone's article offers a taxonomy, a doctrinal stress test, and a proposal for future law. Thank you for watching.